Article 125. Delay and the delivery of detained person to the proper judicial authorities. The penalty provided and the public officer of employee who shall detain any person who some illegal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for a crimes of offense punishable by a light penalties of their equivalent 18 hours of crimes or offense punishable by correctional penalties or their equivalent of the 36 hours for crimes or offense punishable by afflictive or capital penalties or their equivalent. In every case, the person detained shall be informed of the cause of his detention or shall be allowed, upon his request, to communicate and confer at any time with his attorney or counsel. Number 1. What are the elements of Article 125? Element. Number 1. That the offender is a public officer or employee. In Tagalog, na ang may sala ay isang opisyal, publiko o empleyado. Number 2, that he has detained a person who some illegal grounds. In Tagalog, na ang kinulong niya ang isang tao sa legal na dahilan. Number 3, that he fails to deliver such a person to the proper judicial authorities within A. 12 hours for crimes or offense punishable by a light penalties or their equivalent, or B. 18 hours for a crimes or offense punishable by correctional penalties or their equivalent, or C. 36 hours for crimes or offense punishable by affected capital penalties or their equivalent. Nabigo niyang maihabla sa korte ang tao sa loob ng A. 10 oras para sa krimen na may parusang light penalty sa mga katumbas nito, and B. 18 oras para sa krimen na may parusang koreksyonal sa mga katumbas nito, and C. 36 na oras para sa krimen na may parusang affective o capital penalties sa mga katumbas nito, and 2. What is the crime committed if the offender is a private person? If the offender is private person, the crime is illegal detention. In Tagalog, kung ang may sala ay isang pribadong tao, ang krimen ay illegal na detention. And 3. What does the phrase shall detain any person who some illegal grounds mean? Under Article 125, the public officer or employee has detained the offender party for some legal grounds. The detention is legal in the beginning because the person detained was arrested under any of the circumstances where arrest without warrant is authorized by law. The detention become illegal after the certain period of the time because the offended party is not delivered to the proper judicial authority within the period specified by Article 125. In Tagalog, sa ilalim ng Article 125, ang opisyal publiko o empleyado ay nagkulong ng agrebyadong tao sa legal na kadahilanan. Ang pagkakulong ay legal sa simula dahil ang taong ikinulong ay huli sa ilalim ng alinman sa mga pangyayari sa kung saan ang paghuli ng walang warrant ay pinahihintulutan ng batas. Ang pagkulong ay maging illegal pagkatapos ng ilang oras dahil ang nag-agrebadong tao ay hindi basampahan ng kaso sa loob ng panahon na itinakda ang Article 125. Number 4, does article apply when the arrest is by virtue of warrant of arrest? Article 125 applies only when the arrest is made within a warrant of arrest but arrest must be lawful. Mag-apply lamang ang Article 125 kung ang paghuli ay ginawa na walang argumentong aresto, pero pag nahuli ay dapat naayos sa batas. If the arrest is made with a warrant of arrest, the person arrested can be detained indefinitely until his case is decided by the court or he posts a bail for his temporary release. Kung ang paghuli ay ginawa ng may mandatong aresto, ang taong nahuli ay pwedeng maikulong sa hindi tiyak na hanggang ang kaniyang kaso ay mapapasyahan ng korte o di kaya pansamantalang makalaya o samantalang paglaya. The reason for this is that there is ready a compliant or informed filed against him with the court which issue the order of warrant of arrest, and it is not necessary to deliver the person thus arrested to the court. Ang rason nito ay meron ng demand na naisampa laban sa kanya sa korte na naglabas ng mandatong aresto at hindi kailangan na sampahan pa siya ng kaso sa korte. And 5, what is the disposition of person arrested with a warrant? In case filling under paragraph A and B of section 5 rule 113, the person arrested without a warrant shall be forthwith delivered to the nearest police station or jail, and he shall be proceed against in accordance with Rule 122 and Section 7 and Section 5 Rule 113 Revised Rule of Criminal Procedure. So, sa mga kasong pasok sa ilalim ng mga talatang A at B ng Section 5 Rule 113, ang taong huhulihin na walang mandato ay kinakailangan dalhin kaagad sa pinakamalapit na himpilan ng pulisya or jail at siya ay ipoproseso batay sa Rule 112, Section 7, Section 5 Rule 113 and Revised Rule of Criminal Procedure. Section 7 Rule 112 of the Revised Rule of Criminal Procedure state that when a person shall lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the compliance of information may be filled by a prosecution without need of such investigation provided unrequisite has been conducted in accordance with existing rule and absent of validity of unrequisite prosecutors. The compliant may be fined by the offender party or a peace officer directly within the proper court or the basis of the affidavit of the offended party or arresting officer or person. Kung ang isang tao ay legal na huli na walang mandato kung ugnayan ng isang krimen na nangangailangan ng preliminary investigation, ang reklamo ay pwedeng isampa sa pamamagitan ng prosecutor na walang kailangan na ngayong investigasyon pero dapat may request na ginawa batay sa umiiral na rule. Kung walang prosecutor na magsasagawa ng request, ang reklamo ay pwedeng isampa sa pamamagitan ng naagrabyadong tao o alagad ng batas direct sa akmang korte based sa affidavit ng naagrabyadong tao sa humuling opisyal o tao. Number 6. What is the meaning of the phrase shall fail to deliver such a person to the proper judicial authorities? If will be note that what constitution a violation of Article 125 is the failure to deliver the person arrested to the proper judicial authorities within the period specified therein. In Tagalog, ang natatandaan na ang paglabag sa Article 125 ay may bigong pagsampa ng kaso sa akmang korte sa loob ng oras na isinasaad nito. And 7, when do we say that the duty of detainee officer is demanded complied with? The duty of the detainee officer is deemed comply with upon the filing of the compliant with the judicial authorities. In Tagalog, ang tungkulin ng nalukon na alagad ng batas ay masasabing natupad na sa pamamagitan ng pagsampa ng reklamo sa korte. And 8, what is the meaning of a phrase proper judicial authorities? The term judicial authorities as used in Article 125 means the court of justice of judge of a said court vested with the judicial power to order the temporary detention or confinement of a person charged with having committed a public offense. That is the Supreme Court and such a inferior courts has may be stable by law. And Section 1, Article 8 of the 1987 Constitution. Ang termino ng judicial authority na ginagamit sa Article 125 ay nangangahulugan ng korte ng hustisya o mga hustisya na huwes ng nabanggit na mga korte na pinapagkalooban ng kapangyarihan na iluklok sa korte ng mga utos sa pansamantalang pagkakakulong ng tao na pinagtanggihan ng pagkakagawa ng krimen. Iyan ay ang Korteng Suprema at ang korteng nasa ilalim nito. Number 9, what if the judge is not able? What shall be done with the detainee person? So, where a judge is not able to arresting officer is duty to release a detainee person is if the maximum hours of detention provided under Article 125 of the Revised Penal Code has already expired. Failure to cause the release may result in an offense under Article 125. In Tagalog, kung walang huwes ang humuhuling alagad ng batas ay walang tungkuling palayain ang nakakakulong na tao kung ang ang pinakamataas na oras para sa pagkakulong ayon sa Article 125 ang Revised Penal Code ay patapos na. Bigong mapagbigyan ang tao ay ang resulta sa isang krimen sa ilalim ng Article 125. Number 10, what is the procedure to follow if arrested person by virtue of arrest without warrant asks for a preliminary investigation? Before the compliant of information is filled, the person arrested may ask for a preliminary investigation in accordance with the rule, but the must that Revised Penal Code as amended in the presence of his counsel. In standing the waiver, he may apply for bail and investigation must be detained with 15 days from his inscription in Section 7, Paragraph 2, Rule 112, Revised Rule of Criminal Procedure. Bago ang reklamo ay isampa, ang huhulihing tao ay pwedeng humingi ng preliminary investigation alinsunod sa rule, pero kailangan niyang pumirma ng waiver sa provision ng Article 125 ng Revised Penal Code as amended. Sa prehensya ng kanyang abogado, kahit na may waiver na, pwede pa rin siyang mag-apply ng bail at ang investigasyon ay kailangan matapos sa loob ng 15 araw mula noong simula ito. In Section 7, Paragraph 2, Rule 122, and Revised Rule of Criminal Procedure.